Good afternoon, everyone. Thanks for choosing to spend part of your lunch with me today. I've chosen to speak to you about representing clients at PIRHs. I am a barrister that's done inquest work for the entirety of my time at the bar, and it's increased as time has gone by effectively. And so I thought that this was a practical topic that I could explore in a fairly short time frame over lunch, and might be helpful, perhaps just a point or two to assist you in your work with your clients. So hopefully I won't detain you much beyond half an hour to 40 minutes. And I think we may have had a few technical issues, both at my side and in chambers today. So my apologies for that. You should be able to see my screen, I'm hoping. Can everybody see my screen? Yep, perfect. Thanks, Anne-Marie. Really helpful. So without further ado, I'll get on with the presentation. So the purpose then for today is to explore issues which arise at PIR, and essentially to give a roadmap through the hearing. Obviously, we'll have lots of different perspectives in the virtual room today, and that's important in terms of your client's perspective, but it's important to recognise the limitations of the coronial jurisdiction, to note where we can if there are admissions, and to manage expectations as a primary starting point, really, for all clients, but be they IPs who are of a medical nature, the prison service, or indeed if it's a family that's your client. For most PIRs, we have the agenda and varying practices in relation to that, which I'll come on to later. And then just a general point that the purpose of today is to assist with confidence in relation to representing clients at PIR and in front of coroners who sometimes, because of the nature of the jurisdiction, there is an element of just the unexpected. One doesn't really know what a coroner is like until you're in front of them, whereas and each area has its own way of doing things, which adds to the complexity. So before the PIR, we are really hoping that we'll get written directions from the coroner. And this is supposed to be 2 weeks or so in advance, according to the chief coroner. In my experience, I don't know about others, but essentially, I find that it's often not the case that you get your written directions necessarily. And we can turn up to court not really knowing what's going to be the issues for the coroner. But in terms of best practice, obviously those written directions would come to all of the IPs. In terms of the purpose of the PIR from the bench point of view, obviously it allows the coroner to give us as IPs their provisional views and just outline the issues from their perspective. And that takes me nicely on to the next point of outlining the scope and any controversial issues, including Article 2. You get an insight there from the written directions from the coroner's perspective. In terms of written submissions, it's very often the case that written directions will invite submissions from the parties as to any particular issues that's within the coroner's scope, or indeed written submissions on other issues that the parties may well think is of relevance that the coroner hasn't mentioned. My experience in terms of the agenda in advance is pretty patchy. There are areas where you will always get a very detailed agenda in advance, and thinking of the Northeast in particular, that is an area where for the most part a lot of the coroners send out very detailed agendas in advance with provisional views. Going more south, certainly to the London region, it's been my experience that it can be quite tricky to get an agenda in advance from a coroner down there. I have highlighted on the second bullet point there that one should read chapter 3 of the Coroner's Bench book, and that is the chapter on PIRHs essentially. And it's a good starting point for all of us, no matter how experienced we are, just to go back to that bench book and have a look at how things ought to be done, having regard to the Chief Coroner's guidance. And it's a useful way of approaching a PIR in the absence of an agenda from the coroner. I've highlighted their guidance and working knowledge, and obviously you'll all be, for the most part, experienced in this area of work, and have counsel that you use, or indeed do your own hearings, so you can inform your approach to any given PIR with that as a matter of course. The agenda, from my perspective, is designed, my perspective both as an advocate and as an assistant coroner, is to add value to the proceedings and to the IPs, to make sure that they can get the most out of the hearing. And in terms of a general point, it's my practice as an advocate and as a coroner that the agenda sets the tone really for the inquest proper. It sets out the issues, and it's really helpful in terms of just making sure that the IPs get off on the right footing. I've highlighted from the bench book for you, part 3, the key elements of the PIR, in particular an agenda in advance, the hearing, formal rulings and directions, and the minutes or a note of the outcomes for the directions for future actions. And it's important in terms of case planning that both advocates and those preparing the case take a note of and take notice of those minutes that come out after the hearing, in order that timelines and expectations can be met, both expectations for the coroner and of the coroner. So just things that it's important to think about in terms of what a PIR is likely to include. Obviously, if you've got the agenda that's been sent out by the coroner, all well and good. But if you haven't, then the common themes that we should always be looking at in these cases is firstly the identity of any IPs. And you may feel that there are additional IPs that the coroner hasn't picked up, and in your written submissions, that would be the opportunity to pop that detail in. Secondly, the scope of the inquest, fairly obvious, often one of the most contentious aspects of a PIR, alongside whether or not the procedural obligations of Article 2 are engaged or not. Obviously, the purpose of this talk is quite limited. So in terms of whether the principles that you would apply for Article 2 would be the subject of a different talk. But certainly in my experience, it would be the kind of thing that a coroner would give you their provisional view on. And if you were minded to object or to seek to challenge that, then written submissions would be the way forward on that. Similarly, as to whether a jury is required. Matters for further investigation and outstanding disclosure, both to and by the coroner, those aspects are really bread and butter for a PIR. And what we're hoping for is that the coroners have sent us the disclosure bundle in advance, and that we've had a good opportunity to go through that and see what things are missing, take our clients' instructions, and be able to ask for relevant information that we think is not there. In terms of the a provisional list of witnesses, it's my practice as an advocate that when I have the bundle sent out pre-disclosure, I essentially go through it looking at each witness to see whether it's a witness that I would call or wish to read, or indeed would have any questions or issues of controversy around. And I would recommend that as a practice for everyone undertaking a PIR. Is useful in terms of case preparation in any event. Obviously, the next item, any special measures required for witnesses, those obviously pop up on a case-by-case basis. And I've highlighted the devising of the bundle, core documents, index for a jury bundle if required, and then the usual listing elements for either a PIR or final hearing. Those are all the things that one would expect to be covered at a PIR. So I'm hoping having that there as a handy pop-up for you, you would be able to use that in the future in terms of PIRs that you have coming up in terms of case preparation. The bench book also highlights some more complex cases and where additional items may be important or become important. And these topics generally include anonymity, public interest immunity, the need for an interpreter, obviously any disclosure of CCTV or body-worn video evidence. That's going to be an issue, obviously, if you've got Article 2 inquests with state involvement in particular. And there's likely to be the need for a PIR undertakings, cross undertakings for the disclosure of that evidence. In my experience, it's rarely the case that the coroner will feel the need to show any form of CCTV or body worn video at the hearing in circumstances where the evidence can be viewed by the IPs beforehand and essentially agreed thereafter. In addition, obviously, there's the option of viewing the scene in more complex inquiries and investigations, and whether in fact we need some exclusion of the public from the inquest. Again, issues that commonly arise in more complex inquests. In terms of going back to my views and take on the opportunities that present themselves at PIRs, in my view, submissions are a superb way of making a paper foundation of your arguments that you can then advance in an oral fashion at the hearing. And when they're made in a timely manner, that's the optimum opportunity really to get in front of the coroner and seek to influence their thinking on the case. So I've highlighted the first bullet point there as seeking views, and essentially that's what the coroner is doing in sending out the written agenda. And those views are being asked for in an open way. So I would definitely say one of the best things to do is to try and advance a written argument as to IP scope and any areas of controversy as fully as you can on paper, so that they can be explored and the coroner can sit and think about those submissions prior to the hearing. In terms of Article 2, I think it's important always to bear in mind the threshold for Article 2, and in particular the case law of Morahan, Maguire, Rabone, to take a realistic approach and to advise your clients of that realistic approach that's required. And that always Article 2 is likely to be the subject of argument unless it's pretty obvious on the papers that it falls within the mandatory sections. But a lack of Article 2 status doesn't necessarily either limit the scope in practice of the inquest, or indeed the actions that can be taken afterward. Just in terms of jury, for those cases where a jury is mandated, we ought to be thinking at PIR about any admissions that can be agreed between the parties, any evidence that can be read, and the earlier that process is started, the better, really. In terms of disclosure, we need to be thinking about disclosure that's relevant to scope, and in that regard, we need to pair our requests for scope to the evidence that we have and the evidence that we think is missing. Obviously, I've alluded to witnesses earlier in my discussion and talk, and I've highlighted read. It is the case, obviously, with all of our cases, but certainly I think with coronial work, where the scope and the limitations of the jurisdiction in relation to the lack of civil, the lack of criminal liability, that we need to be focused as to what we're trying to achieve by the questions we ask of the witnesses. So we need to have a laser focus really on the disclosure that's provided from the coroner, read everything, and then send back in to the coroner a table with each witness listed, and with reasons as to whether we think the witness should be called, and whether the witness can go via Rule 23 or not, and be prepared to be challenged in relation to that, to give our reasons why we think the questions are relevant. And in my experience, coroners are willing to allow questions to be put to witnesses where in particular the family have some deep concerns as to the involvement of that witness in relation to how their loved one came by their death. Just in terms of scope, it's I think it's important to bear in mind that the scope of an inquest is going to be varied depending on the particular facts of the inquest and how the 4 statutory questions land in relation to those particular facts. I've highlighted for you there Lord Burnett's I suppose foundation in relation to what scope actually means, and that it really doesn't have any special meaning beyond the fact that it is those issues which are relevant on the evidence. And as is said there, by scope, all that is generally meant is a list of the topics upon which the coroner, in the coroner's discretion, will call relevant evidence so as to be able to answer those 4 key statutory questions: who died, how, when, and where did they come by their death. If you wish to challenge the scope that's outlined by the coroner, my advice is to be confident in doing so, to advance a consideration of alternative scope where you're instructed to do so, and to do so by reference to the evidence. And at the heart of it, what your client is wanting the coroner to look at. So be clear and open. Obviously, on the other side of that, one is always hoping to manage the expectations of our clients, given the limitations of the jurisdiction and the coronial scope. I've just highlighted at the bottom there to be respectful in the sense of we know as lawyers that coroners have a very wide jurisdiction, and that jurisdiction really and their discretion is limited only by irrationality and Wednesbury principles. So, well, notwithstanding, one coroner might make a decision that a different coroner would make a different decision. it doesn't make the coroner that's limited scope necessarily wrong or unreasonable. One has to take a measured approach and build our argument as to what should be in scope from the evidence or lack thereof. Just in terms of expert evidence, I often find that I'm instructed to ask for expert evidence at PIR, not unsurprisingly, given that it's an opportunity that the IPs have to try and affect the agenda of the inquest hearing. So I've again alluded to the broad discretion and have just signposted to the bench book and the old law sheet number 5. Obviously, the bench book has overtaken the former coroner's guidance sheets and the like, but there is still merit to going back to the older documents, albeit perhaps not referencing them in court and more make reference to the bench book. Expert evidence is going to be decided by what is reasonably required to answer those 4 questions, and the sufficiency of investigation. To note that the coroner is obliged, as part of a lawful inquest, to provide a medical cause of death and a conclusion. And we can see, I think, far more easily in relation to medical inquests, baby deaths and matters of that nature, where the coroner will be assisted by an expert to answer the question of how the deceased has come by their death. I have been in courts where coroners have been scathing about not wishing to trouble the inquest with an expert, but in my view, where it's reasonably required, we should make an absolute effort to persuade a coroner that actually, in order to make sure that their investigation is sufficient, in order to ensure that we don't have any issues on causation, as to causation of death, it's important in appropriate cases to have that expert evidence. I have highlighted Lepage there and Takushi for you, just in relation to firstly discretion and the notion of allaying rumours and suspicion. Obviously, part of an inquest is that it goes through a process that allows the IPs and families in particular to have confidence that the issues have been explored, and actually, as a matter of fact, on the evidence before the coroner, they can feel confident that that trouble or that issue that they were suspicious about actually was not worthy of their suspicion, based on both the factual evidence that and the questions that have been put to the witnesses, but also the paper evidence, and that can assist you in asking a coroner, in the circumstances, given the level of suspicion, that an expert may well in fact assist. In addition, just on Takushi there, about the fact that the coroner, an IP who wished the coroner to call an expert, should put the substance of that evidence before the coroner. And I think, as a matter of common courtesy, it's useful to have that information, that argument on paper before the coroner, in response to their written directions on their agenda, or indeed to highlight it as an issue by emailing the office if in fact you haven't received a written agenda in the usual way. Just in terms of submissions and communications and practicalities, you, I'm sure, are all aware that the bench book and recent guidance requires that communications with the coroner and their office should be open communications, and they should be communicated in a way where all IPs are included in that communication. I've just highlighted for you there the cardinal principle, obviously from Bell, a civil case, but the cardinal principle being that the conduct of proceedings before the court, absent an identified compelling reason, a party's communications with the court on matters of substance or procedure must always be copied in to the other parties to the proceedings. Inappropriate and unjust to seek to communicate with the court without this transparency. And obviously the exception there is within the bit quoted. Essentially, if you have a compelling reason why you've not done that, tell the coroner and let the coroner know so that the coroner can take a view and communicate with you thereafter as to whether they agree or disagree. In terms of the PIR hearing itself, obviously the expectation is that this will be a public hearing, and the date will be published in advance of the hearing to make it lawful. Any exclusions to that, obviously the press and the public can be excused and can be excluded from the hearing where it's in the interest of justice to do so, or indeed on grounds of national security. And those issues are things that one would expect to be highlighted to the coroner and their office in advance of the hearing. In terms of the press, I recently had a situation where the family, it was likely to be a suicide conclusion. It had been all over the press, and there were young children involved. And the family were very, very concerned about further press comments, really, in their locality. And the officers took the steps to have a chat with the press, obviously noting that it's completely open, an open court. But the press who were sat in court took the view that if it was distressing the family that much, that personally, individually, they took the view that they would leave the courtroom for the purposes of that hearing. Now, that's not always going to be the view taken by the reporters, but certainly it's an option to be explored with officers when you are representing clients who have that sensitivity. Just in terms of evidence, oh, actually, before I move on to evidence, I've highlighted their IPs with a question mark. Should we ever exclude an IP? I think the primary answer to that is probably not, because an IP has the power to ask questions once an IP has accepted IP status. That said, there can be tricky issues that occur in court when an IP, perhaps in person, is behaving in a manner which is not conducive to getting the hearing concluded or running the hearing in an appropriate way. So in terms of IPs, I would suggest that excluding them would be a final resort. And other ways would be canvass, such as the coroner, essentially listening to the questions for relevance and then asking the questions of that IP to ensure that we have open and full access to justice. So moving on then to evidence, should evidence ever be taken at a PIR? The short answer to that question is no. It's not the forum, it's not a mini inquest. It is in fact a procedural hearing that allows a coroner and the IPs to see the roadmap through to the final inquest. It's becoming more and more prevalent, I would say, in recent years, for the competencies for representatives to be highlighted by coroners. Obviously, more and more we are seeing represented clients and more and more contentious inquests coming to us as legal representatives, but coming in to the public eye in the form of news reports as to opening of inquests and the process of inquests. It's incumbent upon those of us who act within the jurisdiction to ensure that we are familiar with those competencies that are set out by the BSB and indeed the SRA. And if you haven't watched them in recent times, I would advise going back and having a look at those and seeing whether there's been any updates since you last viewed them. Obviously, handling cases, handling witnesses, handling clients in the coronial jurisdiction is slightly different to that in the civil and criminal context. We have the propensity for often emotional displays and seeing the human disposition at its worst. And it's an important way for an advocate or indeed a representative to just remind themselves of methods and tools for de-escalating those aspects of what can be quite tricky litigation for members of the public, both those who are giving evidence on behalf of IPs who may well be perceived to have done some wrongdoing, and of course for family members as well. So just in terms of headlines for my talk, really leaving you with 4 points. Firstly, in terms of PIRs, use the bench book agenda as preparation where you don't get one. And where you don't get one, still send in your submissions, even if they're uninvited, because it shows the coroner that you have these issues to raise, you're raising them in advance, you're distributing them to the other IPs, and you're trying to be open and transparent and deal with the issues from your client's perspective. Secondly, to manage expectations. Can be tricky to do that, especially when we're acting on behalf of families whose expectations are the world, and there's very little that we can do to bring those down. But in my experience, chipping away at those, reinforcing the jurisdiction, the limitations of the 4 questions, and that even with an adverse or not the best result at inquest, it doesn't prevent further steps going forward. Thirdly, discretion. Just reminding ourselves that every now and again, when we profoundly disagree with the coroner, that discretion is broad and fettered only by irrationality and the Wednesbury principles. And where we feel appropriate to challenge, but there does come a point when one has to accept the lay of the land and be respectful. Fourthly, to follow the evidence, both in terms of who the IPs are, what the scope is, and whether we need an expert, and to base your submissions on the evidence, because going to the evidence is going to be the strongest way of having a coroner change their mind, essentially, and come back to your way of looking at the papers, the evidence that's missing, the sufficiency of investigation. But it's starting from the papers to take a coroner who's against you, to turn them round and take them with you. And I think I've managed to squidge all that in to well, just over my half an hour. So there is the possibility of questions if anybody has any, but if not, that's absolutely fine, and I can bring the meeting to a close. I think I'm going from that there aren't any questions. So I'd like to say thank you to everybody who attended. Apologies again for the technical difficulties. And obviously, if you wish to raise any questions privately, please do drop me an email. Thank you so much for attending.